Hello, my name is Haesun Kim, advisor of Gangnam Labor Law Firm. Today with Labor attorney Jung Bong-soo, we will introduce and explain about the scope of becoming the member of labor union. So could you explain the concept of this scope of qualification, please?
Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. Today I'd like to talk about scope of labor union membership. So according to Labor Union Act, Article 5, it describes workers are free to establish a labor union and can join labor union membership. So this is it means every employee can they make a labor union. Also, they can join union membership in that labor union. So it's up to their own choice. So that is the principle. So exception is like some the limited part of labor union, like when labor union they belong to certain category where non-union member joined, then such a union is nullified, so they cannot get any confirmation from to government authority. So those labor union who didn't receive some qualification or registration, then a union cannot be protected by this Labor Union Act, such as application for mediation or applying for the unfair labor practices. So these are very important because they are designed to protect the labor union and related workers. So it is very important to have a justifiable union. So according to the labor standard, especially Article 2-2, so it describes who is the employer. Employee means the employer and some management assigned person. Also those people who are working on behalf of the employer. So maybe HR team, they can be those people. So also those people who are working for the interest of labor, interest of some employer, they are excluded from the becoming member of the union membership. So why it's important if union include those people who are not who are not qualified, such as HR team or finance team or some secretary or some department head. If they join the labor union, then those union is regarded as a non-qualified union. Then they cannot apply for remedy or mediation process. To go on strike, they must go through mediation processes. Then those labor union that was established not by Union Act, they cannot be protected by this Labor Union Act. So they need to keep, they need to follow the union membership. So usually union membership is decided by their unions by law. So those people who belong to the employee, they can join labor union. However, some exceptional cases by mutual agreement between employer and the labor union, such as Hyundai Motors company, they described those with a section manager, they are now allowed to join labor union. So only the membership is allowed to those with the assistant manager's title, not the manager's title. So this shows some who can join the union or who cannot join labor union. Yeah.
So as you said, the HR head or like secretary, department head, and those are not qualified for the labor union. In such case, then if they are not satisfied about the company regulation, how can they appeal? If they are not qualified to become the member of a labor union, how can they appeal?
So those union that was not satisfied by this legal requirement, then the other side, like a company, can take it legal action to the labor office. Then labor office found out that those who doesn't belong to a union and become labor union members, then the labor ministry office will give some notice if union cannot delete or cannot exclude those who belong to the employees group. They maintained this kind of some non-workers side, then it become reason for like unqualified. That means a union cannot take strike, or they cannot be protected from unfair labor practice. Also, they cannot apply for remedy application.
I see. So when there's a labor union members, then they would elect the representative and some other representative people to negotiate on collective agreement, and is that their major role?
Oh, maybe you mean labor union?
Yeah, labor union representative.
Yeah. So labor union's main goal is to improve working condition through collective agreement. So they must establish the collective agreement the way they can accept. So collective agreement has a very powerful application. So if it is passed by mutual agreement, then those condition is strongly applied, better than rules of employment. I mean, this collective agreement has a very powerful application influence. So if there are conflict between collective agreement and rules of employment, then the items stipulated in collective agreement is applied preferentially.
I see. So collective agreement is always becoming the superior, right, rules in the working environment compared to the rules of employment. Superior.
Yeah. That's right. Yeah, because the mutual agreement is regarded the number one application. Yeah, so it is important for the company to recognize the qualified members of labor union. Yeah.
So could you explain, introduce us very briefly about what the labor sample of labor union in Korea? Which company, for example?
If you visit our website, especially a template site where you can find some template regarding that case. Yeah. So don't worry, just visit our mobile app, then you can find. Yeah.
I see. Thank you very much for your explanation.
Okay, thank you for watching. Okay, bye bye.